I've kind of set the stage here for this civil war, for lack of a better way to put it, the civil war between stepmom and stepkids. And that will be the theme we keep coming to as we do these next several shows.
Life's Third Act is a podcast dedicated to helping you get the most out of your retirement. Sponsored by Tucker Allen. Here's attorney CPA Joe Cordell.
So today we're picking up with part 2 of Frank Sinatra's life and career and estate planning. Those of you who've watched episode 1, I hope all of you have, then episode 1, focuses on his early career and his mid-career. So today we're going to talk about the last years of his career as well as the estate planning process and what we can learn from it. So let's go over his 3 children, each of them.
So we've got Nancy, who is his first and eldest daughter, or his first child and eldest daughter, and then Frank Sinatra Jr., who was Sinatra's only son, and he was the middle child, and then Christina, but she goes by Tina Sinatra, and she was the youngest child.
And these kids all really looked up to and worshiped their dad,
Yes.
which it's not surprising to hear. And another characteristic of Frank that I respect is, though I don't respect the adultery that happened with respect to the first marriage, at least we know it happened. But I do respect the fact that he has an one writer called it a Sicilian view regarding family, meaning that even when you divorce, unless there's somebody else that's come in and the person's remarried that's taken responsibility. Absent that, that wife that you divorced, you're still responsible for. And so he continued to provide support and have positive relationship with his 3 ex-wives, and especially Nancy, who was his first wife, and continued to provide financial support, had a very positive relationship with her over the years, believe it or not, would regularly go visit her house. She would make his favorite Italian meals. She was a marvelous cook by all accounts. And he continued to care for her and take care of her. And the children, because of this relationship, which actually improved beginning in the 70s, that they really thought that Dad would remarry Mom. I think it was a fantasy that Nancy especially nurtured and was surprised, so I'm told, or so authors have suggested, was surprised whenever Frank made the decision to marry Barbara. They somehow didn't think that was going to result in marriage, and they really thought he was going to get together with Mom. I'm sure there had even been some conversations along that line. I'm speculating. But for them to be convinced that was a very conceivable thing, I suspect there have been conversations at least.
Yeah, I agree. I definitely think that it was, I think the big factor was the kids just thinking it, but I do think that there was still some sort of love between him and Nancy, his first wife, but I think Barbara, he loved way more and in the right way that he needed to. But I don't think that it was ever a for sure thing that they would get back together or get married. I think they both maybe thought that, but he just loved Barbara so much more and knew that was the right choice for him.
Yeah, she had been married to Zeppo Marx, who one of the Marx brothers, who I don't know much about. Some of our viewers may, but this set the stage for what really is going to be the focus of this show, and the focus of this channel really is what can we learn about estate planning gone wrong. And the stage is set where you have this stepmom who comes in and, in the view of the children, manages to lure insinuates herself between their mother and their dad, and doubtlessly regarded her as a gold digger. I'm sure there are all these opinions they had. I can't form an opinion about her because I know less about her than I do the first wife, and I'll just say that this stage was set for conflict when they married, and then it was magnified by a couple of things surrounding the wedding. Can you talk about that?
So whenever they got married, Barbara and Frank, he actually hadn't annulled his first marriage through the Catholic Church with Nancy. But him and Barbara got married, and Frank was coming back into his religion at that point in time. And he went to the church and got his marriage with Nancy annulled so that he could technically be married to Barbara under the Catholic Church's
And now,
eye.
and maybe some of our viewers can comment on this, but I'm surprised that the Catholic Church would grant that. They had been married. He had been married to his first wife like 11 years or
Mhm.
12 years, and they have these 3 children who are adults. I can definitely see why the children were angry at this, and
Yeah.
especially if Barbara had anything to do with it. And I wonder. So if Barbara was a moving force or even a substantial contributing force, I can see how the children would be very offended at that, because you think about what are the implications to them if the marriage didn't exist. And we don't, and
Yes.
no, we, let me hurry to add, this is not an impact legally for those of you who aren't clear on the distinction. The Catholic Church annulling it is only a thing related to the church. It's not legal. So it's not as if these children become illegitimate legally. But from the standpoint of the church, which in believers' minds is a standpoint that matters most, I would think that this would be really a problem for the kids. Not if she had no role, meaning if she was saying, no, no, no,
Yes.
Frank, don't do it, don't do it, don't do it. But by all accounts, given the children's anger at her, I my impression is that she was a moving force.
Everything you build for you and your family deserves protecting. All of those important assets you have worked so hard to acquire and enjoy, you want to make sure they're handled with care. At Tucker Allen, our attorneys will customize an estate plan that will work for you and your family's goals and needs. Tucker Allen, estate planning, probate, and trust administration. Visit tuckerallen.com.
I agree. And I think that was just like the tip of the iceberg with everything. And then it started just going downhill from there because towards the end of Frank's life, like we were talking about earlier, she kind of cut them off from him. And she kind of made it really hard for them to see him and to know what was going on. And they didn't really know, that his health was declining or anything like that up until he died, unfortunately.
Yeah, yeah, that is shocking. And so that people understand those last years, he died in 98.
Mhm.
He had, some say that he had the beginning of Alzheimer's, but still his cognitive abilities had substantially declined. So he was really within the control of Barbara. And Barbara, let me tell you, she guarded access to him like a fortress. And the kids have written, Christine has written, Tina, as she's called. Tina has written very persuasively in her biography, in her life of her relationship with her dad. Uh, I believe her when she said that, you had to make an appointment. You had to jump through hoops in order to get in to see their dad. At times when their dad was functional, though still a little bit debilitated, but still functional, could have gone to events and things. They would want him to appear at events that they were involved with, whether it's a charity or whatever, things that they know their dad would have been perfectly willing to do. They would not get that because Barbara really controlled his decision. So it's not so much Barbara is not saying, well, I'm not going to tell him. Instead, Barbara presents it and controls the answer. So we all know how that can happen, just having undue influence over someone, and that's what the law calls it, where someone's will is essentially subordinated to another person. And it's all too common with people who are aging and are in the care of it could be a hospice person, it could be just a home care person. And there's always the risk that that person will induce them through just their influence to change estate plans, to write somebody out of a will, to disinherit someone. So Barbara, I'm trying to be fair to her, but you can tell I have a bias in this. You can tell I'm a little biased just based on the information I have against Barbara in this scenario, but I'm sure she has her side of the story. I'm sure the kids were not pleasant to her, but I do believe, having listened to Tina and Nancy talk about a number of these things, I think that probably Barbara did not do what she could to maintain that relationship. But there's probably nothing she could have done, in fairness to her, that would have made this perfectly harmonious or even harmonious in any sense. But anyway, so in his last years, they saw very little of him, to the point that when he died, or let's say he was on his deathbed, Barbara did not initiate a call to the kids. Of course, the doctor knew, and the doctor is the one who initiated the call to the kids. And to me, this is a very damning sort of fact, if that's true. Why would Barbara have not initiated that communication? It just seems very mean-spirited to me. Some of you watching who may see this from a different perspective, I'm curious what your thoughts or comments would be. But it was bad at the end, and none of the three children cared for Barbara. Apparently, she had a bad relationship with all three. So he dies in her care. He was in California at the time.
Yes, he was in California.
Yeah,
That's correct.
he had several mansions and lived very well. So that doesn't. I'm sure Barbara probably deserves some sort of medal for being able to live with Frank Sinatra, particularly in those declining years. I'm sure it wasn't easy, but I've kind of set the stage here for this civil war, for lack of a better way to put it, the civil war between stepmom and stepkids. And that will be the theme we keep coming to as we do these next several shows, because it's so rich with material. There's so many examples of cases where stepmom, not stepdad, stepmom and the stepkids, they have a war of sorts. And even if they don't have an actual war, it's a cold war. So it can be a hot war, it can be a cold war. But it produces a bad situation in the family, one that the father in this example would not have wanted. And fathers, I think, in that scenario fail to plan adequately. But let's talk about how Frank Sinatra did his planning. So we'll kind of shift gears here. Is there anything else, Marley, you want to add up into his death that I've kind of...
No, I think we've covered all of it. I think that was a very good overview.
Okay. So when we look at what Frank Sinatra did in his planning, a lot of it was very savvy. I mean, there were things that he did that were good things and things we should all remember. And then there are things that I think he could have done better. But let me tell you, I think the good things are more numerous than the bad. Let's face it, for reasons we've already talked about here, this is a situation he couldn't fix completely. There was bad blood here, and it had gotten worse. Frank Sinatra had declined in terms of his ability to manage it, something that we should all think about. We all assume that up until the day we die, we'll be in a position to manage things. But as you get older and decline, you're less and less able. So it's not so much a matter that there's a point in time in which a switch happens. The day before the switch occurs, you're perfect, and then after, you can't do anything. It's not that simple. Often it's just a very slow, even shallow decline where all of a sudden you just aren't able to get the things done you should have. And I would argue that in the 90s, he died in 98. I would argue that probably through most of the 90s, he wasn't as focused as he should have been. I saw him in concert in 91 at the Fox. 91? 90. Saw him in 90 at the Fox. Yeah, I was dating my wife to-be, and I thought I would really impress her with Frank Sinatra. So these tickets were $50 a piece, which at the time, those who are old enough to remember, those were expensive seats. So I put together $100, and so I pick her up and I take her to see Frank Sinatra. And now my wife's a little younger than I am, and she may not have fully appreciated the magnitude of this event. So we get to Fox, and we're halfway through the show, and I'm just stunned. Everything he's doing marvelously. Yes, his voice is not quite what it was, but you don't expect that when you see a legend, 30 years into their career. But he was just marvelous. His presence on stage, he was definitely the chairman. And so I'm soaking this up thinking, man, I've hit a home run here with Yvonne. And I look over, she's asleep. So that there's somehow a age gap or something, generation gap. She's not that much younger than I am. I won't tell you exactly, but she's not that much younger. The point is, she's not as impressed with Frank Sinatra as I was.
Well, my wife fell asleep when we went and saw Rush, but I don't know. Frank Sinatra's a bit bigger a deal.
Even though I like Rush, your wife has a better argument than my wife, I would argue.
Yes.
In any case, so Frank Sinatra was good then, but he was declining. So maybe he was okay then. But the last years, I think that he wasn't. I don't expect him to have gone in and made a lot of changes. So the estate planning that he put in place in 1992 was actually very good. You can be sure that he had excellent lawyers that were hired. So when I talk to you about the things that I think he did right, they're pretty important things. And one could argue that if anybody in this situation manages to pull this off, it's the best you can hope for. But I'm going to suggest a few additional things. So here's the situation. I'm not going to go into a lot of detail, in part because no one knows it, meaning Frank Sinatra created a living trust. Many of you know what that is. It's a revocable trust. And then he also created a will. And the will has basic information, has some specific bequests. So we know that he gave like $1 million to Barbara. He gave $1 million to Nancy, his first wife. We know that he made some gifts to people that were important in his life. We know that some specific items, personalty items, he specified in that will. But the will is not that particularly interesting. And you wonder, well, how can you have such a will with somebody who is so wealthy and has so many assets? How can you dispose of them this way? Well, actually, this will, it wasn't quite a pour-over will, because a pour-over will simply says, whatever is in my estate, I want it to go into my living trust that I created 10 years ago. So there's nothing interesting in there. In this case, he did have some bequests in the will. The will was a number of pages, like 11 or 15 pages. So there were some things in there. If those of you who want to look it up, you can actually find it. It's a public document. But I'm breezing past it because what's really important about that will is its provision, its residuary clause, which essentially dumped things back into the living trust. So the living trust ended up being the master plan for his estate. And of course, there are several trusts because his intention was not for these parties, meaning the step mom and the step kids, to have to interact any more than was necessary. And that's part of the brilliance. That's part of the good planning that I think is essential in this scenario. And he understood that if he forced them into being business partners where they had to make decisions about intellectual property, all those things we've talked about on the show, I mean, that's an ongoing active business over decades. And he foresaw that would be a problem. So he put all the assets in the trust, actually more than one trust, and through subtrusts. And so the kids were, on one hand, they were given a set of assets. His wife was given another set of assets. And his wife was provided very generously. Now, keep in mind, anything that he acquired, that he earned from the time that they were married up into death, they lived in California. It's a community property state. So the presumption is that 50% of whatever that gain in assets that occurred during that period of time, and I'm sure it was, 40, 50 million. So it was a substantial amount of money. That half of that she would already have a claim to. So if he had disinherited, quote unquote, Barbara entirely, she would have been fine still. just based on what because even though he wasn't out having hit records, he did do the duet series in the 90s. There were a lot of remakes of his albums that occurred in the 90s that there was this new popularity, this revival in a way with people who were 30-ish in the 90s. So Frank Sinatra generated a lot of income in a decade when he wasn't really getting out doing much work. He did do some tours, but I think most of his income was coming from these recordings. And of course, there's also other ways in which his image or his likeness was used to promote products and whatnot. So Barbara would have been fine anyway. So keep in mind when we talk about whatever she got in his estate planning, there's still this 50% of what was accumulated as marital assets during their marriage. But also, she was given a substantial, significant part of the assets that would have been Frank Sinatra's. He could have left his half entirely to his kids if he'd wanted from that period. But instead, he left her a significant part of those assets. Like also, there was mention of the recordings that were done in the 90s, the duet specifically. Those things, she was given the royalties relating to that and the intellectual property. Regarding, though, the other assets, the ones that would not have been marital, she wouldn't have had a claim to, those before 1976, which would be the bulk of his estate. He gave her some of those, but much of that went to the kids. I read, as I was doing some of the research on this, I read where some felt that the kids' grievance was that they weren't adequately taken care of. I don't think that was it at all. There may have been some complaints by kids, but kids always complain. I think that he was very generous. They got all the intellectual property associated with Reprise Records, except that would have been part of any marital assets after 1976. But as far as I know, I don't know that the label, that he continued to own an interest in that label after 76. So the kids got that. They also had the rights to the Capitol recordings of the 50s. Remember, those were real big in the wee small hours of the morning. There were just some great albums, great mood albums, where he really made, one could argue, he made his place in musical history by what he did in those albums in the late 50s. Many would argue. He introduced the idea of a theme album that hadn't been done before. An album was just after we went from 78s to LPs, long plays, then it was just like 12 songs, that were just thrown on there. And there was no sense that you create this theme and you roll out the theme. And Frank Sinatra was really the first to do that. And thereafter it became standard to do it. Rock albums now do it. Dark Side of the Moon is an example with Pink Floyd of a themed album. Yellow Submarine, Sgt. Pepper's Lonely Hearts Club. These are things that originated with Frank Sinatra. There are many others. Anyway, so back to the property distribution. So he was generous with his children, but most importantly, he divided things in a way that they didn't have to be at business meetings with Barbara, or there was as little of that as possible. Now, some of this, I have to admit, is a little opaque, and when you think I'm being a little vague about exactly who got what, it's because no one knows the specific terms of the living trust. That's the advantage of a trust, is you don't know, and that's the confidentiality. We can't go and pull it from the recorder of deeds or the probate court's records in whatever county you died and where your estate was open. We can do that for wills, but we can't do it for trusts. So the trusts, we don't know whether they continued to manage assets long-term or not, whether there was a distribution to the kids 5 years after his death, 10 years after his death, a day after his death. But my suspicion is that the trustee continued to manage the assets to some extent. The reason I suspect that is that there was a Frank Sinatra Enterprises formed in 2007. So remember, Sinatra died in 98. So 7, we're talking about 9 years later. The kids get together with their interests, and they own interests relating to intellectual property as well, meaning anything related to his name and likeness and recordings. So they were getting money associated with that. Also, just the royalties themselves. And they created this entity, and they put it in partnership with a Warner Brothers entity. And these two together marketed his brand as to that era. So there was some overlapping interest. There were some disputes. But one thing that was especially important in assuring that Barbara and the kids didn't end up in any significant litigation was a no contest clause called an interim clause is what the lawyers call this. And what it said, particularly in Sinatra's case, and Sinatra was I mean, he locked it down with 13 provisions associated with anything in which the children challenged the will or sought to have litigation associated with the will. Now, these no contest clauses only work if you've given something significant to each of the people that you regard as a likely suspect in probate litigation. In other words, if they have nothing to lose, if you disinherit that son or that brother, whoever it is, that you think should have nothing, well, then you have no incentive for them to not litigate. As a matter of fact, there's an incentive for them to litigate, and that's often what happens. So one of the preconditions to having an effective no contest clause is having a provision in which you state that the person is getting something. And in this case, all the likely, for lack of a better phrase, belligerents here, Barbara, the three kids, they all were getting something. They were getting a lot. And so there's incentive on the part of all of them to not challenge it. Now, I do think that Sinatra was probably thinking the likely challenge would come from his kids. He knew Barbara was taken care of, but he was determined that he wanted to discourage his children, who I'm sure he knew couldn't stand Barbara, and he wanted to discourage them. So they were getting enough in assets from what I've described and things I don't know about, but I know that they would have gotten because Barbara didn't get it. And you know, the no contest clause would have caused them to forfeit it if they challenged it. And some of these are written very narrowly so that, you know, you're allowed to challenge certain things. In other words, often people who create these, they're not trying to reach for the outer limits of what the law will enforce, because sometimes you can reach too far and end up with an invalid clause because it tried to do too much. The courts will not enforce a clause that essentially robs the parties of their ability to call the court's attention to fraud or to misconduct or somebody who had this overwhelming undue influence on someone or something that is a forgery. I mean, we can all think of things that are just, they would cry out for the courts to get involved. Well, you can imagine if a no contest clause had no limits, then it could simply say, if anybody raises any voice regarding any matter in my will, challenges it directly, indirectly, in any way, they forfeit their interest. Well, if you're giving a substantial amount to each of these parties, a significant amount, then you've essentially had a chilling effect on justice, and you've allowed somebody to get away with criminal conduct. So there are limits to no contest clause, but I'll tell you that Frank Sinatra took it to what I'm sure are the outer limits of California law. He forbade questions regarding the executor's decision, any question of the executor's judgment regarding what should be an asset of the estate. If anybody raises that, that's a trigger where you forfeit your claim. Anybody who challenges the interpretation by the executor of the will, this will cause a forfeiture. So I look at some of these and I think there's some states that would not have enforced at least those provisions. They may not have thrown out the whole no contest clause, which incidentally some courts can throw it all out when you overreach. It's like a covenant not to compete. If you have a covenant not to compete in an employment contract, you can get so greedy that you say this person can't engage in this profession for the rest of their life in any part of the planet Earth. So it doesn't mean that the court cuts it down to a reasonable level. It means the court throws it out. So you end up with no covenant not to compete. Similar thing here. You can overreach and you end up with no limitation at all in terms of a covenant not to or a no contest clause.
So what would constitute a complaint?
So a complaint would be when somebody files a document with the court and says, I think that Barbara had an undue influence on my dad, and I think that he lost his autonomy in drafting this document. I think this document does not reflect his free will. That's an example. Or I think that that these assets should not have been part of his estate. I think that they should, I have a claim to them. His son could say, really, my dad gave me, all that private record collection that he has in his home. We'll use a personal example. Let's say that he has some items in his home that are very valuable. And the son pops up and says, no, 5 years ago, my dad gave me those. Those are not in the estate. So, and he specifically talks to anybody who claims that he's entered into a contract or a promise or other as to any of the assets claimed by the trustee, that will be, or by the executor, that will be enough to trigger this clause. Now, let me say that all states will allow some safe harbor filing. So if you're a beneficiary and you know that there's a fraudulent document here, you can safely file, despite a no contest clause, you can safely file and challenge that. And if you succeed in most courts in the U.S., then that clause will not cause a forfeiture. So that, as a general rule, if you file a complaint regarding a legitimate matter and succeed, then that will triumph over the no contest clause. And you can also bring an action to ask the court to rule whether something is in violation of the no contest clause. In other words, before you actually file it with the court, you can file a motion, and this on the Uniform Probate Code, you can file a motion and probe and ask the judge, if I do file the attached claim, is this going to cause me to forfeit my estate? So there are ways you can kind of probe and find out before you act so that you're not, surprised. But anyway, Frank wrote this very thoroughly. I'm sure he had great lawyers, and it worked, meaning there was no significant litigation between these parties in the aftermath of his death. Now, these are parties who really, I don't think hate is too strong a word. These parties really hated each other. And I think that everything corroborates that up until their death. I mean, Barbara, when she died, she had a provision that the kids were not to attend, her funeral or whatever what was the reception.
Yeah.
So now I don't know if the kids wanted to go, but there were provisions like that. And another thing, for example, Barbara did was after Frank died, she sold off a lot of the personalty items. She had them sold off that the kids would have liked to have had. And especially when she died, things that she had a claim to because they were acquired either during their marriage or Frank had given them to her. And there are lots of those, that memorabilia. It's not so much its economic value, it's important to the kids. And so she had control of that. When she died, she ordered this stuff be sold so that the kids would not have access to it. So she affirmatively tried to place it in the hands of third parties. She could have said, if she didn't have these feelings, she could have said, let the children have the first right of refusal. If they don't want to buy it, well, I'll let the children buy it. But if they don't want to buy it, then we sell it to third party. That's what somebody would do if, in this scenario, if they didn't have just utter hatred for these kids. But in her case, I mean, at every turn, that was her position. And the kids, I'm sure, had their own reciprocation. So let me talk about, in addition to his no contest provision, which I think was a marvelous idea, the living trust, marvelous idea. Separate trust so that the kids he minimized the entanglements that happen between these kids. We don't want any more entanglements than you have to have. So he minimized that. I would say he eliminated it. And finally, I would say this as an overarching comment about his estate plan. It was tight, meaning it was written in such a way to where there's no ambiguity, no invitation for conflict. Even in the absence of a no contest clause, it still wasn't an invitation for disagreement because there was a lot of clarity. There's clarity around each of the distributions. Often it's just a failure to be specific. And if you have ambiguities among people who hate each other, it's an invitation to litigation and conflict. In this case, he went to great lengths to divide up these entities, to have provisions specifically about contracts with reprise records versus capital records versus the intellectual property from the 90s. So he took with great care to distribute these assets in a way that would not leave ambiguity. So it was tight. It was comprehensive. He covered all the assets. There was nothing stray that could have been a fertile ground for disagreement. He was fair. And fair is a mushy word. But by fair, I mean, yes, the children felt that he should have given them more. I think that Barbara probably felt that he gave the kids too much. But when you step back and look at the plan, you say, well, the wife is very well provided for. The kids are well provided for. He gives money to his first wife. I mean, so you look at how he's distributed it, and it just doesn't have that sort of jolting asymmetry that you sometimes see in estate plans where a parent is mad at a child and they will just exclude the child completely. Or maybe they marry and it's the second wife that gets everything. The kids get, some crumbs. I mean, those are things that jolt you and they don't surprise you when there's litigation. But when there's a plan that at least a third party could argue was fair, then it's much less likely that the kids will think it's so unjust that they have to litigate over it. So it was fair by that definition, and it was a full plan that was backed up, that was fortified by the no contest clause. What are the things I would say that could have been done better? I think that Frank could have tried to mitigate this conflict. I don't think that's asking too much. I'm going to make an assumption here that could be invalid, could be unfair. I don't see in anything that I've read where he's really tried to bring these parties together. He's not going to make the kids like Barb. He's not going to make Barb like the kids, but he could have, for example, been kind of stern and insistent that Barbara be civil with the kids. And while Frank was alive, he could have witnessed it. I mean, he could have done something to somehow diminish this level of resentment and conflict. I see nothing where he's intervening to fix things. It's as if he stepped back and let those forces do their thing. And whether it's fair or not, I'll just say, if he didn't do that, then my complaint is that he should have. And again, it would not have produced a happy, harmonious family, but it might have been the difference between the sort of bad blood that we saw in the aftermath of his death and what it could have been. So failed to adequately consider the importance of personalty items. This is just touching on, there are things that weren't economic in nature that had a whole lot of importance to him. The personalty is all too often treated as an afterthought. So my suspicion, I've not checked the will on this, I think the will just gives the personal property with some specific exceptions. There were some things carved out, some collections. He was a big collector. So he gave some of his collections to his son and to certain specific people. But there's so many things if you think about it. So for him to specify 7 or 8 categories or items is just not enough. So I think there was too little attention given to this massive amount of personal items that had so much meaning to the children, and so they end up for the most part in Barb's hands. Whoever dies is in possession of the hill, so to speak, gets off in the personal property. That's the way estate planning works. Is whoever's in the house and they die, it's up to the other side to be able to recover this ground and recover some of these things, and often it doesn't happen. Things disappear. Just whoever's in control. So Barbara was in control, and Frank failed to deal with all these memoirs and things with sufficient specificity, and I think that was an invitation to a lot of the bad blood. It did not relate to big items; it was to small items. And then I think that the longevity of this trust was probably too brief. It appears to me the trust is not making the decisions as far in 2007 when they formed Frank Sinatra Enterprises. It looks like it's the children or their legal representatives that were kind of guiding the entity and forming this partnership with Warner, and later that was bought in turn by Universal. So there have been business entities that have been protecting his brand and his name, and of course assuring the kids are getting adequately paid. But it appears that the trust may have distributed its assets before '07. I don't know this is true, but how can I know? But I'm just looking at some of these transactions that occurred, and from what I could tell, that the kids are the ones who formed this partnership with Warner. So it wouldn't have been the kids; it would have been the trust or the trustee acting on behalf of the kids. So And I list this, and I don't know if this is true. I don't think that he met with the kids and disclosed to them what the distribution was going to be. And to Barbara, Barbara probably knew. I'm sure she knew. But the kids apparently didn't know what his intention was. And it would have been nice, I think, for him to sit down. And this is a recommendation you've heard before. If you watch this show very much, whether you're rich or poor, you need to talk to your kids in advance about what you're going to do, especially when you have a stepmom and stepkids. You need to talk to them and say, this is the distribution I'm doing. This is why I think it's fair. You may disagree with it, but I want you to know my reasoning. It's hard to make clear to you how disarming that is. It doesn't mean the kids agree. The kids may be mad at you when you say that, but at least they get that it's coming from you and that you have reasons, and reasons presumably that are not nonsense. They're just subject to disagreement. But the point is, it largely eliminates the notion that instead what happened here was a distribution plan that was conceived and executed in the mind of the evil stepmother. And instead it's clear it's a plan that that the dad in this case supported and gave reasons for. Anyway, so those are my complaints. But all in all, I think Frank Sinatra did a very good job with a situation that was probably irreparable. I don't know how, maybe he couldn't have mitigated it at all. And you can see why this topic, which we're going to return to as we keep doing these shows, is so rich with examples. And it's good for all of us to know about these things and to understand them. And this demographic fact where you have a stepmom and stepkids in probate court, it's something that is worthy of our attention. And I think you'll find it also very interesting. Anyway, this has been another episode of Life's Third Act. Marley, thank you. Till next time, take care.
You've been listening to Life's Third Act, a podcast for thriving in retirement. Sponsored by Tucker Allen, your estate and elder law advisors. Each week we discuss topics and answer questions to help you better plan for your future. For more information, visit tuckerallen.com. Subscribe and listen again next week for another edition of Life's Third Act. The choice of a lawyer is an important decision and should not be based solely on advertisements.